Okay, this is part 5 of a video series where I'm reading parts of a transcript of a case that I tried going back to May of 1990, where I was representing someone who was sued in a sledding accident case. Come join me as I share with you the remaining part of this fascinating closing remarks. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer representing injured victims here in New York. So now, here's the scenario in case you haven't seen any of the other prior videos. Back before I started my career representing injured victims, for the first 4 years of my legal career, I represented people who were sued in accidents as well as doctors and hospitals. So now, in this particular case, this sledding accident case, a gentleman and his wife go to a winter resort up in the Poconos. And now he grabs a little flying saucer sled, going down a hill. He's going faster, he's spinning around, and at the bottom of the hill he hits something and now goes flying and fractures his tailbone, his coccyx. So now, this is closing remarks I made in Nassau County in May of 1990. So now let's pick up where I left off, reading the closing remarks. This is fascinating. And by the way, I'm telling you about the plaintiff's argument, which is that they should have had warning signs in the area where they were sledding. So I'm ridiculing the plaintiff's argument that this makes absolutely no common sense whatsoever. Here we go. Maybe you could have a sign, "Don't play tennis. You could get hit in the eye by a ball." Or how about this one, by the swimming pool, "Don't swim. You could drown." Now, where does it end? You have 400 acres. Are you going to post guards at each particular hill? Are you going to put people all around 24 hours a day with signs, with cameras, with everything guarding everything? No, you can't do it because people have to have common sense. A sign isn't needed here. Common sense is needed here. Common sense not to use a hill that's not properly designated, not to use a hill with so many obstructions that could cause an incident like this. Since we don't know what happened, you've got to have common sense. You've got to know to watch out for the barbecue pit, to watch out for a roadway that's traveled at the base of the hill, to watch out for all the trees nearby. Common sense is the key. And I submit to you that the plaintiff is trying to place the blame on us to put signs up, and he's trying to blame us for something that he failed to do. He failed to use common sense. Now, that's a very compelling argument here, because that's one of the key things I was trying to stress to the jury, that the plaintiff was an experienced winter sportsman who knew the inherent risks and dangers of doing various types of winter sports, and yet he ignored those risks and suffered injury as a result of that. And one of the plaintiff's arguments was, hey, this is a dangerous area, and you failed to put up signs to notify us about that fact. So I said, where does it stop, ladies and gentlemen? People must accept responsibility for their own actions. They must. Society, you, ladies and gentlemen, as members of the jury and as members of society, must not allow people to shrug off their responsibilities. Someone gets on a sled, assumes dangers and risks, knowing what they are, goes down a hill and tries to put the blame on us. This isn't right. It's absolutely not right. If you recall, at the beginning of this case, I stood before you and told you what we intended to show in this case. We intended to show that it was unreasonable for this man to get on this hill. We intended to show that this man voluntarily engaged in an activity that was inherently dangerous, that he used a sled which was not his own, that he took, which certainly was not provided by the hotel, to engage in an activity in an area he should never have been in. This was not a designated area. If he wanted to go sledding, he should have done it by the bowling alley. I also mentioned to you that if someone had asked where they were to go sledding, that we would show it would be by the bowling alley. And the owner's son had told you that the area he was sledding that day on the day of his accident was not a proper place to be sledding because of all the obstructions that were clearly visible. And I intended to show that the grounds were well maintained and that this man was entirely responsible for his own accident, nobody else. And I trust that I've lived up to my promise to prove all those things to you, ladies and gentlemen. And at this point, I ask you to return a verdict in favor of my client Winterclove and find no liability. Also, since this is the last chance I will have to speak to you, after I sit down, the plaintiff will then get a chance to talk to you. There may be some issues that he will raise that I will not have addressed, and I will only ask that whatever issues he may raise that I don't address, that you yourselves address them as I would, combined with your recollection of the testimony and what was said in this courtroom. I thank you for your patience and your time. So, you want to learn what actually happened? What was the verdict in this case? The verdict was a defense verdict. I won the case on behalf of my clients, and the jury was 100% correct to return a verdict basically saying, listen, Mr. Plaintiff, Mr. Injured Victim, you knew the inherent dangers. You never should have been on this area, and now you're trying to sue us. You're trying to claim that we are responsible for not warning you and not providing you with a safe place to go sledding? That was preposterous, and I'm glad that a jury in Nassau County was able to recognize this fact and do the right thing and return a verdict in our favor. Now, you may think that's kind of weird because now all I do in my career is represent injured victims. But I share this with you because it's a fascinating look at closing remarks in one key incident, an accident, involving a gentleman who was sledding, who got injured, and now tried to place the blame on somebody where blame should never have been. Instead, he should have been looking in the mirror and realized, you know what? This was all my fault. And I shouldn't be suing this winter resort for my accident. You know, I realize you're watching these series of videos to get an insight and an understanding into what goes on in the trial process in these accident cases here in the state of New York. Well, as always, if you have any legal questions about your particular matter and you're considering bringing a lawsuit for your accident, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, I do this every single day and I'd love to talk to you. You can reach me at 516-487-8207. Come here. Come tell them what my email address is.
Or you can contact me at lawman10@yahoo.
No, Gerry at Oginski-Law.
Oh, or Gerry at Oginski-Law.com.
That's Gerry, Gerry, at Oginski-Law.com. That's it for today's quick video. I'm Gerry Oginski. This is my son David. Have a wonderful day.